to In the Balance, the Iowa Judicial Branch podcast. Welcome to In the Balance, a podcast dedicated to exploring Iowa's judicial system. I'm your host, Abhash Shrestha. In this episode, we examine the unique challenges and responsibilities of representing yourself in the courts. For this episode, I had a chance to talk with two Iowa judicial magistrates. Let me begin this podcast with my first guest, Magistrate Beth Tigges. She serves in the Polk County and previously served as public defender in Story and Polk County. So welcome to In the Balance, Magistrate Tigges.
Thank you.
Thank you. Thank you for coming to talk about representing yourself, as yourself means the public. So could you tell us a little bit of experience regarding people who represent themselves come to your court about?
Okay, sure. I would like to do that. And so I am a magistrate in Polk County. And in Polk County, we oversee three dockets, the mental health docket, the traffic docket, and small claims docket. And in the mental health docket, people are automatically appointed an attorney. They're allowed to have representation. In traffic and small claims, that's not the case. I would say the vast majority of cases on those two dockets, people are representing themselves.
And for all of those cases, do you have any ratio of how many people want to represent themselves versus how many people bring their lawyers in?
In regards to traffic, I would say when you're dealing with a speeding ticket or running a red light or anything like that, I would say probably 95% of people represent themselves. If it's a simple misdemeanor, such as a theft or a drug paraphernalia charge, I would say the number is less, that maybe 50% represent themselves, because under Iowa law, if there is a possibility of jail time, as there is in a simple misdemeanor, they can apply for a court-appointed attorney through the public defender's office. And so a good portion of the people are eligible to have an attorney. And so they take advantage of that.
From your experience being a magistrate, why do you think people actually represent themselves instead of getting an attorney?
I think it's actually pretty simple. They want to tell their story. They want to be heard. They've been wronged in some way, particularly in small claims. We see so many construction cases, as we call them, where they have hired a contractor or somebody to do work on their home, and something has gone wrong. And it's emotional for people when they come into small claims. And they want to tell their story. They want to be heard. And I think that's understandable. And the other thing too is that I would like to think we have made the system user-friendly so that they can come in and advocate for themselves and represent themselves.
So I bet there are lots of misconceptions about representing yourself and probably for detriment of the case itself. What kind of misconceptions have you actually heard?
The issue is what is relevant to the law, and having it be a very concise situation. And so, like, a good example would be for traffic. And so somebody is wanting to dispute whether or not they ran a red light. And they want to talk about the 10 minutes that happened before, that, there was a car behind them that was acting funny, or that, there's all these scenarios that they think is relevant, or where they were trying to get to, or things of that nature. And really, it's just those 5 seconds of when they approached the light. Did they go while it was red, or did they stay put? And so I think that's the thing, is that there's always an explanation that they want to give but under the law, is that relevant? Is it necessary? I think another issue that comes up often is in regards to hearsay. Particularly like if they've purchased a car or they've had a contractor go bad. They've always talked to another mechanic or they've always talked to another contractor, and this person did, egregious work. And well, unfortunately, that second opinion isn't in my courtroom, and so I can't take that into consideration of what they said. And so I think that can be frustrating to people as to how they got to the point where they wanted to sue and they feel like they've have proof of their case, but it may not be something that I can take into consideration.
Well, people want to take a chance on themselves, and when they come in, they might have not been well prepared. How should the people dress and behave when coming in front of the courts and representing themselves?
I'm not expecting you to put on your Sunday best to come in to argue a case. I think what it really comes down to is being prepared. Because I get it all the time where they walk in and they're like, well, I didn't know today was the day that I was going to have to present my case. And then, they want to show me something that's on their phone. And I have to explain to them, if I look at something on your phone, then I have to take your phone into evidence. Um, and so, of course, they don't want me to look at it then. And so, I think that's the main thing that I could tell people is to be prepared, to have all your documents ready. It is important to be prepared, to know when you're walking in that today is the day of your trial, that you're going to have to explain to me why you deserve the compensation that you're asking for or why you deserve to not be guilty of this traffic citation.
Is it the same in case of the virtual proceedings as well?
Virtual is a little bit of a different ballgame. Aside from mental health, which is all done virtually, we do all of our hearings by Zoom. And that is so that the respondent or the client in the case does not have to leave the hospital. They can stay safe in the confinement of the hospital. And plus we have so many hospitals that people are all over the state. And so it's just more economical that way as well. And so other than mental health, I would say only about 5% of our hearings are done by virtual. 0% are done in traffic. We just do not do that. In regards to small claims, the cases that we see that we are allowing to do by Zoom are like debt collection. Again, you have an attorney that is representing an agency where they're trying to collect funds. We see a lot of attorneys from out of state or from a far distance, and it's just not logical for them to appear on a case that 75% of the time the defendant doesn't even show up. But then, when they do show up, the hearing, literally can last 15 minutes. And so we do allow the attorney to appear virtually.
What do you think is the most important thing to consider while representing yourself?
Well, aside from being prepared, I think the other thing I would say is that when you walk into the courthouse, that you understand um, that every person you run into is part of the system. And so I would ask that you treat the clerks, the court attendant, um, the security, the person checking you in with the same level of respect and that you would treat me during the proceeding. And that I understand that you might be emotional and that I understand that this is the most important thing that is going on in your arena at this point in time, and that I understand it's probably the first time you've ever walked into a courthouse. I get that. And so that I'm trying to be respectful of that, and that I would just ask for the same respect in turn.
Awesome. Thank you so much, Magistrate Tiggis. And this was an excellent advice for our listeners. And as I said before, we have a second guest for this episode. Let me introduce Magistrate Arthur Eric New. Magistrate New serves in Carroll County and has been serving since 1999. And he is here to talk about representing yourself. Welcome to In the Balance, Magistrate New.
Good morning.
Good morning. Today's our conversation is regarding representing yourself, and you being a magistrate for one of our courts in Iowa, you have the first-hand experience on looking at people who represent themselves. So could you tell me a little bit of how often does that happen?
Well, it's going to vary from county to county depending on workload, but in most counties, certainly in Carroll County, that happens basically once a week when we hold court, and anytime we have a small claim. Obviously, we have other interactions with the public, but that's the most likely scenario, a small claim trial.
Do the people usually have specific cases that you often see them representing themselves, or is it like spread out all within different types of cases?
Probably the most common is what's called a forcible entry and detainer. It's for the removal of a tenant for one reason or another. But those, we probably have the most of those, but next in line would basically be simple disputes between two individuals who just aren't able to work out the arrangement. Maybe they had an oral agreement, something like that. They disagreed, so we end up catching it and having to help them resolve that. Then we also do a lot of collection small claim lawsuits, but again, very few of those end up in court. It's mostly the disputes among just individuals who are unable to work out their issues.
What resources are available for people representing themselves in courts?
There are a number of resources at the Iowa Judicial Branch's website. I would tell you that very few people actually go and review those materials. There's obviously at the Judicial Branch website, there's a topic under the For the Public tab, representing yourself, which does a really nice job of laying out what you should expect and what you need to do and how you need to prepare for coming to court. There are also a series of online forms which are very helpful for everything, not just small claims, but certainly those forms and procedures are contained there. But that's a really good resource.
And what kind of help can judge or court personnel give to self-represented litigants?
Well, and that is also covered at the website. But the bottom line is that the clerks are essentially the keepers of the records. So they are not responsible, nor are they allowed by law to give legal advice. They are required in small claims to assist in the completion of the forms, but that doesn't mean they're going to tell you how to set out your claim. It means that they'll help you. This is where you sign, and this is how you file it. But in general, the clerk's office in particular cannot give legal advice, although people ask for it all the time there because the lawyers, they are expensive, and a lot of people want to try and resolve it themselves. The clerk's office would hopefully refer you back to the Judicial Branch website and say, you're on your own there. Same way with the judges. When you get into the courtroom, obviously magistrates, no judges can give legal advice, but we also recognize in a small claim that for the majority of the time, these litigants do not have an attorney, so they're going to be in a new world. Might be the first time they've been there. So procedurally, a magistrate should certainly help them through the process. And the magistrate, it varies, but generally speaking, I'll ask questions if I think there's additional facts I need to understand, because we are tracking this and trying to decide, is this a contract case? Is this a tort case? What are we talking about here? So of course the magistrate is going to try and guide that. That is different from providing legal advice. We're just assisting in building a record so we can rule.
How would you say would be a good advice for them if they're presenting themselves in physical form, say the dress code, any behavioral conduct?
Well, we used to have a standard. We used to always say, come dressed as you would to church. I don't know that standard works anymore. It seems a lot of variation in what you can wear to church, so I'm not sure that's helpful. But there is also guidance at the website. Just generally speaking, dress respectfully in clean clothes. I think a lot of people would say dress as if you were going to a funeral, or dress as if you were going to church, or dress as if you were going to something resembling an important meeting or gathering. In court, no hats. Out in rural Iowa, that's a tough one because I think everybody gets up and puts a hat on. They're not very happy to have to take it off. And we have to be a little careful that we also have some people who are wearing some kind of headgear which is religiously related, and that would be a different standard, of course. But ball caps and the like, someone's going to tell you to take them off, and it's probably going to be a little embarrassing. Obviously, you certainly want to avoid swearing, or cursing, unless you're quoting someone. It's not that it's unacceptable, just don't do it as part of your opinion. And this is another one that seems to be a problem. You really want to be polite and respectful to the other participants. We understand that when you get there, things are heated. You have a disagreement that you can't resolve, but you get nowhere from mistreating someone in front of the magistrate. In fact, obviously, it can run back to your credibility if you can't control yourself. So that's sort of general guidance for when you're in the courtroom. Dress appropriately, no hats, be polite, try to avoid swearing unless it's relevant.
And what about if it's virtually?
So we have not had a lot of experience with that, but obviously since COVID, one way or another, we've all been involved. So even when it's on Zoom, or virtually, there does seem to be a tendency to really dress down. I'm just going to sit at my kitchen table or on my couch and put my phone on my lap, and I can't see the people, I can't hear them. So it's not, in addition to dressing exactly in the same fashion as you would if you were coming to court, set yourself up in front of whether it be your phone or your camera, and do a few test runs of this thing. Zoom, it's easy to do on Zoom. You can go
Absolutely.
Make sure you can see yourself, that you're being heard. Don't be in the back of the room. We want to see your face. That's a big part of the virtual issue. I think there actually probably should be more guidance on that. Certainly, we've been involved in situations where someone is actually sitting maybe 30 feet away from the camera in a couch. I can't see them. And we need to be able to see them. That's the whole point of having video-based or virtual testimony, so we can lay eyes on each other as testimony is being given. So again, dress in the same fashion. And also do a dry run. Make sure that you're set up where all the litigants can see you. You're probably going to be on a screen on the side of a wall of the courtroom, and you're going to be, blown up so we can see you. But if you're sitting back and away, or the camera's looking at the ceiling, also, don't let the kids run around. You really have to reduce the ambient noise. Don't let your kids run around. Don't have your cat jumping around the place. That always seems, I don't know why the cats are just attracted to these things. Dogs barking. You really want to be in an isolated room. And the reason for that is if you break up your testimony, it's hard for us to understand it when you're messing with other distractions. So it really needs to be a distraction-free environment when you're doing it.
Definitely. And is it acceptable to bring electronic devices into the courtroom, or are there any restrictions for the use of it?
Yeah, it again doesn't seem to come up too often out here. Generally speaking, it's my understanding you don't get to record anything. People have asked me to record the proceedings. I always tell them, no, I'm recording them. And you, of course, have a right to that, because the public may or may not know. Certainly every litigated small claim or litigated trial or motion where there's a hearing with actual evidence is recorded by the court system, and that is available after the close of the proceedings. And usually when I tell people that, then they don't have a problem with it. But that does go also to another thing I forgot to mention, silence your phone.
Yeah.
But it's the same issue.
Definitely. You don't want to be having your phone ring or anything happen when you're making a case for yourself. How should people representing themselves in court behave if they disagree with the judge's ruling during a hearing or trial rules against them? Are they told about the appeals?
So initially, if they're not lawyers involved, you don't get much in the way of objections. So the court tends to take most evidence in. If there's a problem, the court might just decide, hey, you're just going too far afield here. But generally speaking, there are not a lot of rulings. But certainly if you were to, for example, object to hearsay and the ruling doesn't go your way, obviously the best response is the same as lawyers. Say thank you and move along. Don't argue at that point. The decision's been made. The referee has already called. You're not going to get anything out of arguing at that point. More commonly, however, is when the ruling is issued. So you have a small claim, you've gotten to the end of it. And of course, any judge, the court can rule at that time. This is my ruling. And then don't argue with the judge. And the standard response is, you don't understand, judge, you forgot about this, you forgot about that. In a small claim, that's you're probably wasting your breath. But you do have 20 days to file an appeal, and that's on the bottom of the order. I believe I don't rule from the bench very often. I can tell you why I don't. But we're supposed to inform them of their 20-day right to appeal, which they have 20 days to file that notice of appeal in writing with the clerk's office. And that's, of course, if you have a problem, that's where it goes. And then usually a district associate judge will review the record, and you'll have another opportunity to at least argue your point to that individual. That's certainly the preferred way to do it. Arguing with the judge once they've made a decision is not helpful. Talking over the judge or talking over any witnesses, not helpful.
How should self-represented litigants organize and present their documents to the courts to maintain professionalism and to make their cases?
I think the most important thing, and it's also mentioned at the court's website, although it's the last thing, and that really is be prepared and be organized. As a magistrate, we deal with a lot of people who don't have attorneys, and we know that. And we know that they're not used to coming to court. But certainly, the more organized you can be, the better. Understand too, and I think this is a mistake a lot of self-represented litigants make. They don't bring any copies of their documents. They just bring one set. And you really need to bring an original and a couple of sets of copies. It will still work, but it just takes a lot more time to coordinate. Also, and this happens all the time, people bring texts on their phones as evidence. And that's really problematic, because really the only way we can deal with that is to take their phone into into evidence, and they won't see their phone for 20, 40, 60 days, depending on how long things take. So texts need to be printed, copies made. Videos are another problem. You can't just pop up your phone and expect us to look at it. That you need to bring a video on a flash drive or some other sort of media. So as part of being organized, you understand that we're not going to let you come in and just read a speech. A lot of people like to do that. I'm just going to read this, Your Honor, but it has to be in the form of questions and answers. So, and the magistrate will help that, of course. But again, going back to being organized, bringing those exhibits and copies of them, and dealing with text and videos in a way where we can actually take it into the record and consider it, because we want to consider those things, particularly texts, which seem to form the basis of a lot of contracts between people these days.
So most of the evidence that people, when they're representing themselves, if you are presenting as an evidence, the court will take it, else it won't be an evidence, right?
Right. And very few people want to give up their phones for 60 minutes, let alone 60 days. So and then they'll ask, well, can I have more time? No, not usually. We're there to resolve it on this day. So we can't just be pushing these off because you didn't bring it the right way, within reason, of course.
Thank you so much, Magistrate New, for all these great information you provided, and thanks again to Magistrate Tigges for a great conversation regarding to this topic. I'm very certain our listeners learned a great deal about representing yourself in the Iowa court system. And if you like this podcast, we'll return next month with another informative topic. Until then, thank you for listening to In the Balance.